Supplementary list. Pronouncement of judgment. Item 1 to 7.
Now, it's possible to read the operative part also since it's pretty long. So the only is just the result award of maximum uniform rate for the categories of land by reference code as assessed by the collector is upheld. However, the award of decrees shall stand modified as per findings of judgment recorded in paragraphs 40 to 44 thereof, with regard to grant of interest on section 8 to be only an enhanced compensation and not an entire sum, which includes the award, and further the correct discrepancy with regard to grant of future interest, deduction of the awarded amount under section 11, and the correction of the grant salatium on entire compensation. Yes.
Any mention? Lordship, I beg to mention item number 20 for 2 weeks.
Who's the other side? Who's appearing? For who? No objection?
No objection.
2 weeks.
Much obliged, Lordship.
Yes. Yes, make it quick.
May I please, Lordship, I beg to mention item number 19.
Who mentioned 20 just now? See, 22 and 21, 22 connected to that matter. Have you informed other councils? You inform them and come back and mention later when the matter is called out. 2020, yes.
Lordship, I beg to mention item number 19.
19. Yes, also for the petitioner.
I've written math. I've written
After
math.
1 week, Lordship.
1 week, yes.
Your pleasure.
May it please your Lordship. Lordship, I beg to mention item number 15 of the daily list.
Of the?
Of the daily list. Conducting counsel, Mr. Hassan has some personal difficulty.
Why, what personal difficulty?
He just had a dental
Suppose you
surgery.
said?
He just had a dental surgery, so his cheeks are completely swollen, madam.
Sure, okay.
After 2 weeks, madam.
After?
After 2 weeks.
Yes.
And for the private respondents, 8 to 12. Much obliged.
Lordship, I beg to mention item number 18. After 2 weeks, Your Lordship.
Who's the other side?
May I please, Your Lordship?
You're on the other side, 18.
My Lord, I am appearing on behalf of UGC.
In number 18.
Yes, madam.
You have any objections to adjournment?
No, madam.
1 week, 2 weeks.
2 weeks, Your Lordship.
Okay, yes. Make it quick, yes. Yes.
Lordship, I beg to mention item number 23, Lordship.
23.
23.
So for the respondent number 2 to 4.
Yeah, objection.
No, Your Lordship.
No one.
Your Lordship, we intend to file a rejoinder. We are also praying for 2 weeks' time.
Has it been closed or are you applying for the petitioner or for the respondent?
For the respondents.
Rejoinder or affidavit?
A rejoinder, Your Lordship. They have to file additional affidavit.
Has the court allowed that? Your respondent number?
2 to 4, Your Lordship.
Yes, that Begum.
No, Your Lordship. S. Kharpran.
Who's that Begum?
My senior, Your Lordship.
So last order says that we be allowed to sometimes examine the documents brought on record by the petitioner by your additional affidavit. You want to file a rejoinder to the documents brought on record?
Yes, Your Lordship.
Then you make that prayer. What's your name?
S. Kharpran, Your Lordship.
S. Kharpan. MS S. Kharpan. We have respondent number
2 to 4, Your Lordship.
224. Please that we allowed to file a rejoinder affidavit to the documents brought on record by the petitioner. Prayers always after 2 weeks. Yes.
Obliged,
Oblige,
Lordship.
Your Lordship.
Yes.
Lordship, I beg to mention item number 21 and 22. The conducting counsel is not well today, so matter may be taken up after 2
Who
weeks.
mentioned just now 20?
21 and 22.
Where's the one who mentioned 20 was at council? Yes. Okay, 2 weeks slightly, yes. All of the list.
Supplementary list. Item number 8.
Wait, please.
It must be your first time in Shillong.
Yes, sir. It's a beautiful city and
Yes.
lovely court.
Hope we enjoy your stay.
Yes.
Lordship, item 8 is, this is the same blacklisting. That's what
Item number 8.
8 and 9, a supplementary 8.
Okay.
So these two matters are clubbed. The 8 is pertains to a blacklisting notice that was issued to one of the joint venture partner. I represent the shareholder. The main was issued to a joint venture, which my learned senior is representing.
Because this
He can
has-
start and I can do, because this was one of the
I mean, if it's one,
It's a one-
seven substances,
Please,
we
Malad.
won't need individual submissions.
Well, as the impugn blacklisting order is 3rd December, that's the first annexure issued by the.
That's that page.
It's at page 42, Malads.
Yes.
So that has a long history. The history begins sometime in 2011 when a contract was entered into for 4-laning of a road between Shillong and Nongstein and another road between Shillong and Tura. So the project was completed with delays and all of that in 2018 and we got a completion certificate. But there were disputes between the parties. So as envisaged into the contract, there had to be a dispute resolution board. So the first dispute resolution board was constituted in 2015 and that involves my nominating a person, they're nominating a person and they too will nominate a third. The dispute resolution board comprises 3 persons who are not at all connected with any of the departments or any of, because the main allegation now being made is that I gave bribes to get a favorable order from the DRB in my favor. So the first DRB, which was constituted in 2015, accepted, and because they themselves told the DRB that some of the claims that we had raised were admissible. So they gave us an an order, which they were of course aggrieved by and they were not paying. They invoked the arbitration, matter went to arbitration. Even the arbitrators gave us the first claim number 1, based on what happened in the DRB. Now interim award. That interim award is challenged here, challenged of course before the commercial court, challenged here in 37. Your Lordship's division bench dismisses it. The SLP is also dismissed. They have now paid us that 75 crores plus interest, which is the first part of the claim. So all that is done and dusted. The arguments are now going on because, and there's a second DRB claim also, which is accepting of what we have said. This is tested before the arbitral tribunal. My learned friend concludes his arguments before the arbitral tribunal, final arguments. This happens sometime in August of 2024.
Yes.
In September, this is what is interesting. Lordship turn to the list of dates now. And Lordship comes to the date of 2024. July 2024,
Okay.
we commence our final arguments before the tribunal.
Yes.
We conclude it on 21st August 2024.
Yeah.
They were to begin their reply arguments. Instead, on 3rd September, they file a complaint and a FIR is registered. The allegation in this FIR is, we had placed before the arbitral tribunal ledgers of our accounts to substantiate our claims. We had placed it before the tribunal in 2019 itself. Our witness was cross-examined extensively in those entries. The cross-examination nowhere suggested to this witness that any of this was given as bribe to the officials. The only suggestion made was these are exorbitant expenses and these are inadmissible. A new stand is now sought to be taken, because I am not troubling a Lordship at this stage with the numerous attempts made at various stages to delay the arbitral proceedings that they have done. In fact, the arbitral tribunal notes that as well. I'll read that in a minute. They now allege that these entries pertain to bribes given to officials, although no such suggestion was given during cross-examination of witness, and almost 20 plus questions are put to the witness. This point, that the FIR has been registered, is now placed before the arbitral tribunal. in the FIR, very curiously, my lords, the FIR does not allege bribery or corruption. There is no offence under the PC Act invoked in the FIR, which is very, very interesting. No one else is named as an accused other than the joint venture. The officials, the so-called PW officials who are supposed to have been bribed, are not named as accused. Even till date, they are not named as accused. So it's a very strange kind of a thing.
What's happened to the FIR now?
It's still in the stage of investigation. No, it's nowhere near completion, and we've got anticipatory bail.
Now.
I'm sorry,
It has become unarbitrable now.
but unfortunately, my lords,
Is that their stand?
no.
That we have taken before the arbitral tribunal, my lord.
No. So they filed a section 16. That's why I'm coming to that date, my lords. So your lordships now see what they do before the tribunal on 17 September. On 17 September, they file an application under section 16 saying precisely this, that this is, yes, that this has become non-arbitrable. The tribunal has rejected this, my lords. The tribunal has rejected this section 16 and the tribunal has proceeded to give a final award. Unfortunately, the final award, it is a split award, my lords, majority of 2:1. The majority says there are sub-issues to be determined. Those sub-issues are not framed during the pendency of the arbitration. The majority on its own frames a sub-issue whether these entries will amount to breach, fundamental breach of the contract, not put to either of the parties, and the evidence is not discussed. The tribunal agrees with them that these entries may be indicative of bribery and corruption. So our claim number 2 is rejected. The tribunal still, even the majority of the tribunal awards us claim 1. And as I mentioned, the claim 1 is done and dusted. The amount has also been paid by them. So now we will be taking recourse, to whatever remedies are available to us.
What's happened now? Your claim 2 is rejected totally.
Totally. So our claim 2 is gone. So we'll have to go in a 34 route, which we'll probably be doing very soon because it's a 12th December award. Now on 16, that has been rejected, my lords. Now simultaneous with this filing of 16, they enclose with that 16 application a show cause notice which they're supposed to have issued to us. We never received it till then. For the first time, we are seeing it enclosed with the
16th of
17th of September.
Okay.
17th of September, they filed this application under section 16 before the tribunal, saying that this is some subject matter of an FIR and therefore non-arbitrable. With that section 16 application, they enclose the show cause notice. So what we do, my lords, we reply to the show cause notice. This is a 16th September show cause notice.
Where
Annexure A9, page 1145.
1145.
Please, my lord. Your lordship will notice there are 3 addressees here, and I must inform my lords.
Yes.
Party number 1 is BSCPL Infrastructure. Mr. Prakash is representing them. Item 8.
2 companies involved here.
Yes, there are 2 companies which have, but the second company has gone into liquidation, my lords. There's an proceedings before the NCLT under the IBC.
1145, you say?
145, page 1145, Annexure A9.
1145 or 145?
No, 1145, my lords.
1145 here. In this, it
will be in second petition.
Are you taking second petition?
Second petition.
Second petition.
Yes.
Second petition.
Sorry. Yes.
Annexure A9. There are 3 parties. BSCPL Infrastructure is represented by Mr. Prakash. CNC Construction Limited has gone into liquidation. I am representing the joint venture with whom the contract was entered into by the PWD. Now this show cause notice, the subject itself, lordships will notice, regarding acts of bribery, corruption, falsification, cheating and forgery. The FIR does not deal with bribery or corruption. The FIR is only for the remaining part.
Yes.
The FIR does not name any official who has been bribed. Now your lordships notices there's a whole narration, but para 13 is where it all starts. Para 12 in fact, my lords. Whereas during the arbitration proceedings, instances have come to light from the cross-examination of an official, which culminated on 1710. Well, as this entire ledger was placed in 2019 before the tribunal, that cross-examination, not a single suggestion is given to any witness about bribery or corruption. They say shows evidence that bribes have been given. I'll read the cross-examination, no indication. Para 13, they list out 17 entries in the ledger. And some entries are very interesting. Entry 13.15 is a check of 5 lakhs given to Nongkom We Care Society.
Yes.
This is not a bribe. This was the local administration asking us to give money for improvement of the community facilities.
Yes.
And we've offered this as an explanation. We've answered it in our cross-examination. They now allege all of this is bribes. This is like a CSR, it's corporate social responsibility kind of a. And these are 17 entries. What is interesting is when I show the final order, these 17 entries, my lord will note, pertains to financial year 14-15. This is the financial year 14-15, although it doesn't say in para 13. When my lord will read the final order, lordship will realize that they pertain to financial year 14-15. Whereas the DRB, lordships will be aware, the DRB was constituted in 2015, gave its first decision in 2018, and the DRB are all independent officials. They are the ones approving a claim. Before that, I must also point out, my lords, the revised estimates that we submit goes up to the Ministry of Road Transport and Highways in the Government of India. They are the ones who floated the tender. Till they approve, payment can't be made. So they then transfer the amount to PWD department, which then makes the payment to us. So unless MORTH clears these estimates, they can't be paid. So in a loose kind of a way, my lords, in the final order, they simply say these were also bribes paid to MORTH. There's no evidence for this. There's nothing to show from these ledger entries that this was paid to this officer.
No person was named.
No person named.
Either the state government or independent.
One person from the state government, but not from the MORTH. And PC Act not invoked, my lords. If it's a bribery and corruption of a government official, where's the question of not invoking the PC Act? So this itself shows that this is an afterthought. 5 years after we've played evidence before the tribunal, and long after all these challenges to the interim award are concluded, the money has been paid to us. They now come to the stage of the final arguments and now come up and think up of these things. Now your lordship sees that these are the only entries put to us, the 17 entries. Now my lord will turn to the final order. We file a reply to this. My reply may be also seen. We file a reply to this, which is annexure P60 on 30th September 2024.
That is page
1253, my lords.
1253.
Yes, P60.
Yes.
We've given a very detailed reply setting out all of the, may I refer to page 1255 para 8.
Thereafter and so.
Yes. And the extracts of the finding of the DRB.
Yes.
Interestingly, my lords, they're alleging a corruption, bribery of even DRB officials. I mean, this is taking it to a different level altogether, and none of them is named. I'm supposed to have bribed all of them. And 9, before DRB 2, they had claims, that's also set out. And I give a very detailed explanation in para 14, where I say that the interim award is challenged. All the grounds, including that MORTH was solely liable for the project, all that is rejected up to this court and up to the Supreme Court. All of that has been rejected. Now my lord will turn to para 19, page 1260. If I may read that. Yes. During cross-examination of the arbitration, the authority confronted the witness of the joint venture with documents which were already on record since 2019. The witness gave his replies, and none of the replies showcase any evidence of alleged bribery or illegal gratification given by any of the answering parties to any official or authority. It is thus a figment of the authority's imagination and a mere exercise in creative interpretation to state that any instance came to light. How did it suddenly come to light, my lords? There is not even an inquiry made to substantiate this. The authorities are advised to be extremely careful in making loose allegations such as bribes have been given by you in respect of the incident project to the officials, engineers for obtaining favorable communication letters. All vague. No indication which is the officer to whom I am supposed to have given bribes and for what kind of a favorable communication. None of this is clear from the evidence taken on the date of 17/10/2023 and amounts to mere speculation and baseless allegations on the part of the authority, seeking only to coerce the answering parties and sensationalize a commercial civil dispute. The authorities reminded that it does not have the right to make baseless allegations which can affect the goodwill of the answering parties, who are all entities of repute and standing in the country, and in fact executed a number of large projects of public interest successfully. Now, my lords, in para 13 is where those 17 entries are given. We have given a reply to each of them in the indented portions. The instances of the authorities misreading the entries are glaring. The authority has sought to link a charitable donation, which I pointed out, made by the company to some mysterious act of gratification, although the authority is well aware that the same was made as per a written request from the local administration to assist the local community with accessibility challenges at the Nongkum River. The request was made specifically by the district administration to address the plight of islanders, and being a responsible and concerned company working in the region, the company was placed to make such donations through check. This act of local development and charity done at the request of local administration is now being turned and twisted with authority in a manner which is reprehensible and does no benefit. May I just pause here for a minute, my lords?
Yes.
If I was really giving bribes, who would in a ledger entry actually record all this, my lords? This was being claimed as a business
check.
Yes. It's inconceivable that somebody would give bribe by a check, my lords, with greatest respect. So all these are actually afterthought just to put a scare. I am told, my lords, that the IU in fact addressed a letter to the arbitral tribunal saying please preserve the records because we are investigating an FIR. And if as arbitral tribunal members you get a letter like that, and I will show it from the majority award, they framed issues on this bribery and corruption which were not issues, no, not at all, and not issues framed in the presence of parties during arbitration. So, well, it's a serious concern that you come up with this kind of a figment of your
petitions limited only to the
blacklisting order. So now I'll come to that order, my lords. Yes. I've given such detailed explanation. Your lordship sees all of this. I've in fact quoted Eurasian Equipment, UMC Technologies.
So you replied to the show cause that you were
completely and given a full explanation to each of these entries.
The impugned order?
Yes, the impugned order is at page 42. Now, the bottom of page 45 is what is interesting. Now, let me, before that, my lords. Whereas after the second paragraph, after the proceedings in respect of claim number 1 was over before the tribunal proceeded with the examination of claim number 2, claim in respect of delayed disruption prolongation. Whereas BSC joint venture, which had already filed 16 volumes, which also contained ledgers, vouchers and other documents running into thousands of pages for alleged expenditure required by the execution of the project. What they say, don't say it's 2019, 5 years ago that we filed all these voluminous ledgers. Whereas upon scrutiny of the voluminous ledgers during the proceedings, in reference to quantification of claim number 2, which pertains to delay, disruption, prolongation, it was found that various interspersed in different pages of the ledgers showed clinching material of corruption. Pausing here for a minute, not a single question asked on corruption. The witnesses cross-examined for months on end. And bribe given to erring officials.
Materials were available with them.
Yes, since 2019.
Okay, yes.
How suddenly between his final arguments and the commencement of my learned friend's arguments for the PWD, suddenly they found all of this. Whereas it has come to light as discussed above that the JV and its constituent companies engaged in acts of providing illegal gratification to PWD and other government officials. None of them named in the FIR. PC Act not invoked. There were multiple entries of valuable gifts, wine bottles, whiskey bottles. I mean, this all, now we are getting into more creative imagination. So, whereas instances have come to light in the documents provided by the joint venture in its claim before the tribunal, especially under the head of business promotion account for financial year, this my lord will note, 2014-15. So, that is how old these entries are, 2014-15, and all those 17 entries are listed out. Now, next is what is interesting, my lords. Next, they refer to some material which is not part of the show cause notice.
Where is that?
The next page, 46, second paragraph. They have now started referring to 1516, 1617. This is not part of the show cause notice. No opportunity for me to meet these new, fresh allegations on fresh entries. They set out all these entries. Your Lordships will take it from me. This is not part of the show cause notice. I mean, on the face of it, my lords, this violates natural justice. You're relying on material which is not put to me. And you're barring blacklisting.
You say that the entire transaction with regard to giving of these, freebies was all entered in the ledger.
Yes, they're getting it from the ledger, my lord. All this, they're referring to the entry, which volume, which date.
Exactly, I mean, just...
and not a question put to the witness. It's not that...
Expensive wine for the DRB also.
That's right. It was not as if they were... Well, that's many of this I'm told. In Christmas times and those festival times, you do organize get-togethers and there are purchases made. Well, they are talking of a 1300 crore contract. The ultimate contract value was 2400 crores. And these entries, my lords, if you set aside the entries for the CSR activities, those entries itself come to around 9 lakhs. And these remaining entries put together will be 3 lakhs. And this 3 lakhs is enough to bribe somebody into giving me a 1300 crore contract or increase it to 2400 crore. Well, this is all just wild imagination. But most seriously for this purpose, the second, all these entries not included in the show cause notice, brought up for the first time in the final order, and they've already determined, they say, the second paragraph of page 47, whereas the scale of correct practice.
So which clause of the contract have you supposed to have violated then?
So there are two clauses which they say neither of this is attracted, my lords. Yes. One, they talk of clause 39.
Where's clause 39?
59, sorry, clause 59.
That's a notice inviting tender.
In the notice inviting tender.
Yes.
Which page is that?
It's at 96.
Page 96.
Achha, this is...
Yeah. Page 96.
Okay. Termination clause.
Yes. And the contract was never terminated. It was completed, completion certificate was given. So this clause is not attracted at all. The other clause they refer to is clause 37 of the instruction to bidders. Yes.
Yeah, 37 where they say they'll be liable for blacklisting.
No, nothing, my lords. There's no clause which says, no, not at all. There's no clause which says they'll be liable for blacklisting.
Or debarment.
2010 was a notice to it. I think that was for bid. There's not even a whisper.
Yes. So, my lords, actually there is no basis for the show cause notice, much less for the final order passed on that show cause notice. It's an entire predetermined exercise. That's one of the grounds on which you challenge.
Your argument is that it's totally contrived just to derail the entire
arbitration proceedings. They succeeded in that because my entire claim 2 is rejected. Now I'll just show my lords the majority award, how it has affected me and put me entirely on the back foot. The award is at Annexure P61. I can't argue the merits of the award here, but just to show what impact it has created. Page 1270, Annexure P61. And the relevant portion is para 179. 179, para 179. This is 1348. Page 1348, para 179.
Yes.
Now this is where the majority takes off. After hearing both sides, the tribunal is of the view that the following sub-issues arise, which need to be looked into before arriving. These sub-issues are not put to the parties. When we read the award, we find these sub-issues. Whether the claimant has caused fundamental breach of contract, it was nobody's case, my lords. No notice on fundamental breach ever issued by them. Offering liquor and costly gifts. Whether supplementary agreements altered the date of completion and the effect for the delay so and so. Now this first sub-issue, para 181.
Yes. Reimburse donation.
Police Officers Wives Association, Nongpam We Care Society, Khasi Students Union, Gurudwara Singh Sabha, Badminton. Well, even if these are rejected as business expenditure, saying that, how's this bribes? How are these bribes, my lords? And there are entries in my ledgers. Then, what is surprising is a para 184. It says there are entries of influencing, bribing.
Sales tax officials.
IOCL officials, bank auditors. We don't know who these officials are. Well, it's a tribunal on its own. It's not put to any.
It's surprising claimants asking the state to
reimburse. So, well, this is not put to any witness. I don't know where the tribunal got these findings. Not put to any witness. It was not suggested to any witness. These officials are not even named. So now 186, Your Lordship sees that majority lists out some 51 entries. Well, in each of these entries was available to them from 2019. No suggestion to the witness that these are bribes. I'll now refer to the cross-examination, because it will become abundantly clear how flawed this.
Orders today.
Yes, my lords. Because then what is happening?
Here the Advocate General also.
Yes, my lords, and I appreciate that. Yes. What is happening is this. Of course, the 5-year blacklisting is that I cannot participate in bids that will be floated by the government of Meghalaya. But more seriously, my lords, when I bid, because I'm...
Stigmatized, you mean?
Yes, my lords, it will affect me. So I'm only requesting at this stage, if your lordships will say that this impugn blacklisting order will not come in the way of my participating in bids elsewhere, my lords. Because that is really hurting me. On the face of it, this is illegal. This is clearly violative of natural justice. Material not put to me is relied on, not only by the tribunal, but most importantly, the show cause notice. And these are entries which are there of 2014-15, available with them from 2019, thought of by them only on the eve of their reply arguments, final arguments. So on the face of it, there are at least 4 or 5 for my prima facie case. On just the hardship, my lords, irreversible hardship. If I lose contracts, and my lords, your lordships are aware, these are construction projects. Yes. And the bids are all worth thousands of crores. And I have international projects under execution. So as a contractor, reputation is so important for business people. And if we do have to make disclosures, were you ever blacklisted elsewhere? Right. And they know fully well that this is going to happen. And this is why the eve of the final arguments, they raise this kind of an issue. So I'm earnestly appealing that your lordships will protect us, at least from, this will not come in the way of participating in other bids elsewhere.
Let us hear what has investigation commenced at all?
Yes, my lord, investigation has commenced, my lord. Investigation is going on. And if I place my case in nutshell, my lord, this contract was for 2 laning of Shillong-Tura-Nonstein Road. This contract was given for the amount of 1303 and odd amount, my lord. 1303 crore and odd amount. There was a purported delay of 2.5 years, which resulted in contract in getting enhanced to 2400 crore rupees. 2400 crore rupees was also paid to them, my lord.
No.
2400 crore rupees is paid. There is no dispute about it.
No. 2400 is not paid. The dispute is about non-payment of that.
2400 crore rupees is paid, my lord. I will show from the record.
Very well.
Thereafter, the 2 claims were raised, my lord. One claim was that you did not pay the amount in due time. Therefore, I am entitled to interest. Claim number 1. That matter has also travelled before your lordship in number of occasions. So I was entitled, for example, on 1st January, and you paid it on 31st.
So the same matters.
Same matter. Yes, my lord. Same matter. Same matters. Yes. So yes, my lord. Same matter. Right. So they said that we were entitled to this amount, and therefore we are entitled to interest on that amount. That was the against that interim award was passed, my lord. We came here. Interim award was based on the admission of my chief engineer saying that yes, you are entitled to this amount. And that admission was given based on the bribery, and I have quoted some examples. Thanks to the business account expenditure which they placed it, my lord, we came to know, and kindly see the so cause, my lord. What they say, what is being said by Justice Muralidhar, we have privilege to hear Justice Muralidhar. So that your lordship kindly see the so cause which is at page 1145. This will show the example of bribery.
So how can you reconcile this
I will.
These ledgers were placed.
Yes,
in-
my lord.
at
Now,
during appellate proceedings. As
yes,
far
my
back
lord.
from 19.
Now, my lord, there.
And now, when it comes to the second claim.
Then we started October 23.
Arguments in the middle
No,
of
October
the second
23,
claim,
my lord.
Then you bring that.
Yes, my lord. Now I will answer that part also.
Was there from 2019?
Yes, my lord. Now the two issues are falling for your lordship's consideration. One, whether these examples are examples of bribe or not. Yes, if they are examples, if it has come to light in 24.
What page 1147?
Yes, kindly see, my lord, 1145, and then, my lord, kindly come to the relevant part, my lord, at page 13, paragraph 13, page 1147.
Yes.
These are the some of the examples. Kindly see, whereas such more glaring instances have come to light in the documents provided by the addressee number 3 in its claim before arbitral tribunal, especially under the business promotion account number so and so, cash being paid for purchase of gift items for government and officials. I have given one example, my lord. They have got the business promotion account. They can take out all the cash given. Those are the details. A name is also there, my lord. Now kindly see 113 point, cash being paid for gift article purchase and given to local administration, watch, etc., my lord. Cash being paid to hotel towers, my lord. Cash being paid towards purchase of wine bottle. Do I need to list all expenses here, my lord? That has been done by the arbitral tribunal, my lord. Now, what is the effect of these cash, my lord? Kindly see 13.11, cash being paid towards purchase of title invoice from mega trade for officials, my lord. Cash being paid towards purchase of whiskey bottle towards government official, my lord. This cash, my lord, has cost me about 1100 crore rupees. 1100 crore rupees. I will show you 1100 crore rupees. This has cost me. Now kindly see the clause, my lord. 64, corrupt practices. Whereas clause 37, instruction of bidders, my lord.
Where are you reading from now?
Page 1148, my lord. Next page, my lord.
Yes. Right.
Where clause 37 of instruction to bidders provide corrupt or fraudulent practice, my lord. I have quoted the provisions at the bottom, my lord. At the bottom of this also I say, above said act of corrupt practice in execution of the projects are duly covered under the heading fraudulent practice, and moreover the employer has a right even independent of contract to initiate blacklisting debarment procedure for indulging in corrupt practices. Now I will show how it has resulted in loss, my lord. 16, my lord. That you, the addressee, and your official engage in corrupt and fraudulent practice during the execution project. You, addressee, engage in corrupt practices, influence the action of public official during the duration. And then, my lord, we have issued the so-called. Now, kindly see the reply. What reply is?
When was it issued and when was it received?
This was they have received it, my lord. It is also reflected from reply also, my lord. Kindly see reply. That reply they have answered it. This was issued on 16th September, my lord. And then your lordship will see the page 1260, my lord, is the crux of the matter. But when it comes to reply, my lord, they say that they have received it. Kindly see page 1253, my lord.
Yes.
They say that we state letter under so and so has not been received by all three answering parties. So they say that not all three. I don't know. Or date, as on date. So some of them have received, some of them. The authority instead chose to address the answering parties, filed an application also. We have moved the application, so they have received it. Now, after receiving it, my lord, the reply is, my lord, kindly see the reply. What is the justification which has been just read out, my lord? And that I will show, my lord, justification at 1261, my lord.
Yes.
What is being that it is being done at 1261, my lord, third paragraph, your lordship, kindly see. As a matter of fact, my lord, first, second, third paragraph, 10th, 7th line from the 1261. As a matter of fact, even gifts given by company to its own official on certain festivals which are necessary to ensure that morale of official to a project remain unhindered have been twisted by the authority to nefarious allegation. So they say they have given the gifts
to our own employees.
What they say is that to their own employees, my lord. So now their own ledger entries, my lord, so that these gifts have been given to PWD officials, my lord. Now kindly see, and their own, now they are trying to twist it by saying that no, we have given it to our own employees, my lord. We have listed those items, my lord, saying the name of the officers on everything, my lord, and kindly see the order of blacklisting.
Where are the officers named?
That page is at page 42, my lord.
Yes.
I'll read it slowly, my lord, that at page 43, my lord. Page 43, my lord. Second paragraph. Whereas Messrs BSc CNC joint ventures submitted a bid of 1303 crore 83 lakh so and so, whereas the chief engineer, National Highway, PW, Government of Meghalaya, letter of acceptance dated contract price of 1303 crore rupees, whereas formal agreement was entered between the chief engineer, whereas the contract price and scope of work was subsequently revised on the representation of BSc JV, and accordingly revised cost estimate forming part of supplementary agreement were signed from time to time, and contract price was increased from 1303 crore to, my lord, 2319 crore rupees, my lord. Kindly this whereas the BSc JV raised two disputes, namely first disputes claiming towards payment of cost of extra bitumen, cost of labor cess, and interest on delayed payment. And the second dispute raised by BSc JV pertained to claim regarding delay, disruption and prolongation of the contract. Both the disputes were referred to dispute review board constituted in terms of the contract, where during the adjudication of first dispute, may not kindly mark, the then chief engineer, while later dated 16/5/2016, maintained that the claim of BSc CNC JV are not maintainable and barred by contractual provision. Whereas for inexplicable reasons, within 15 days of earlier stand of department, newly appointed chief engineer, namely M.R. Sangma, he is named accused in the FIR, my lord. While later dated 2nd June and 12th September 2016, admitted the claim of BSc CNC JV, where the dispute made a recommendation of so and so based on admission inter alia contained in communication. Based on the admission, my lord, this amount was made. And contrary to contractual, where now, my lord, kindly see, and then this amount we have to pay based on this admission. Now second, my lord, whereas the amount awarded by dispute resolution board in respect of claim number 1 was increased by adding interest to same to 117 crore was claimed by BSc and arbitrated along with the claim pertaining to second. Whereas BSc JV made a claim towards the second disputes regarding delay, disruption, prolongation of 220 crore 82 lakh 92,000, my lord. There are numerous examples, my lord, of wrongful admission, in as much BSc JV claimed that the plant
so
machine.
Mean to say that this given as freebie is only a tip of the iceberg.
This is tip of the this is the tip of the iceberg, my lord, and my lord.
If that was the indicator, then 2019 should have
No, now there are two. Now there are two parts, my lord. There are two fraud.
The contract completed when?
It was completed on 31st December 2000. Kindly see this line also, my lord.
December
2017, my lord. Kindly see this line, my lord. This line also. This. Now there are numerous examples of wrongful admission in as much as
affidavit, then we can dispose of the next date.
Yes, my lord, because I would be praying that this is a case of fraud and fraud outrightly, my lord. I would be requesting, my lord, not for grant, and I will show from the finding of the arbitral tribunal. Kindly see, arbitral tribunal one.
But you see, Mr. Architect General, only on the question of that comes to mind court is the delay in the entire process. Like, why is it timed at such?
Yes, my lord. Now,
at such a juncture
where
when the tide is gone against you, you come up with this.
Yes, my lord. I will answer it straight away, my lord. The contract was for two claims, my lord. Second claim was delay, disruption, prolongation, where they claim business promotion expenditure. In business promotion expenditure, they filed 16 volumes. In 16 volumes, we started checking those ledger entries one by one, and there are thousands of ledger entries. That was checked in October 23, my lord. Now, they are not denying that they have not paid the amount to the officials, my lord. If they have not paid the amount to officials, whether it comes to light today or after 6 months or after 5 years, my lord, corruption is corruption, fraud is fraud, my lord. And that is why I just wanted to show the one finding of the arbitral tribunal. Kindly see, my lord, because this is the 1348, my lord, which was read out, my lord. Now kindly see 186, my lord. Paragraph page 1350. 1350 of the arbitral award. You know, this is a corruption of gigantic scale, I would say, my lord. That though I have to say, unparalleled, my lord. Page 1350.
Yes, the list.
List, my lord. A very small list. And now kindly see what they are saying.
Yes.
16 and Samsung Galaxy mobile for gifting to senior officers. My lord, this is senior officers, their own. Purchase of wine bottles for sweet for officials. Purchase of Samsung. Now I'll show that. The each and every name is also there, my lord. Name is also there. I split AC for NHI regional office. This is their own office, my lord. I will PW staff Christmas celebration gift item for government officials, my lord. To entry 26, and what the arbitral tribunal has did, SOC page number wise and amount also. They have tabulated the entire details, my lord, and one after the other. Your lordship kindly see. Finding at
Not put to any witness.
now finding, this is their own document. They are not denying it, my lord. They are not denying those. This is their own document, my lord. And 1357, my lord. Kindly see 1357 paragraph 204, my lord. 1357, my lord.
Okay. Yes. Para
4, my lord. The overall contract price is increased from 1303 crore approximately to 2406 crore approximately due to supplementary agreement. It is common sense that extra work cannot be done in the initial, especially the work which is assessed between 2014. Claimant's so-called monthly calculation of work done into account which has been calculated. So, your lordship, the and then last 207, my lord. 207, sorry, paragraph 207, 1358. Last 3 line, my lord. The review order is only signed by chairman, engineers of state, or also. I am reading 207, last 3 lines of the paragraph 207. Page 1358, my lord. Review order is only signed by the chairman. Engineers of state of Meghalaya are also compromised. All such inconsistencies go in to prove that
submission.
Yes, my lord. No, this after submission, my lord. Finding your lordship will find at after that your lordship will find that how they have 194 1355 1355 194 because there are issues by the findings are recorded issue wise. 1355, my lord.
Yes. 1355
194 paragraph, my lord. The arbitral tribunal has also no hesitation in observing that such documents do show connivance of the claimant with the engineers of the site. Even MORTH and DRB also are not beyond suspicion, my lord. Now kindly see the FIR. Say that in the FIR officials have not been named, my lord. One 1371, my friend is one page, my lord. 1371.
1371,
my lord. 238, paragraph 238, my lord.
1371.
Yes, my lord.
Well, this issue is not
having discussed 1371, my lord. Paragraph 238, my lord. Having discussed the above sub-issues, arbitral tribunal look into the whole issue in entirety. A few salient points emerge as follows. The claimant has the temerity to put up the voucher showing offering of liquor, gifts to everybody involved in the process of starting from JE, junior engineer, chief engineer, arranging party for engineers, funding MORTH officials for stay, even members of DRB. Claimant has even asked the arbitral tribunal to reimburse all such expenditure with the interest. These vouchers perhaps explain the argument made by claimant that no letter of claimant has been controverted. Even in DRB, engineers have not put any papers against the claim put by the claimant. The so-called correspondence of the engineer of MOTH in favor of claimant also comes under suspicion. As MOTH or official are to be compromised, perhaps issue of increase of 1303 to 2400 crore also needs re-examination below. The scope of investigation will be, and that some These are the materials which the civil court has, and in your lordship in Kulja, I just want to place the Kulja judgment, my lord. But before that, I just place the FIR, my lord. Kindly see what Learned Senior Counsel has said, that FIR, the officials have not been named. Kindly see, that is not correct in my humble submission, my lord. That kindly see the FIR, which is at page, just give me the page.
Yes.
That is at page 1073, my lord, and 1067, my lord.
And you do one thing, Mr. Captain General, we'll hear the interim matter finally, or maybe the entire matter finally. You put an affidavit.
I'll put
you
the
put within 1 week.
Because records are voluminous, my lord. So at least 2 weeks, lordship, kindly give me, and kindly see.
And meanwhile, we let them take part of the contract.
Your lordship, there because they have no case on merit, my lord. No prima facie case. No prima facie.
Whatever submissions you're making here will go on the record. Then the court will examine it. Because the thing is that
my lord, this is a case of fraud. This is a case of outright fraud.
Right.
This is a case of outright bribery. There is no balance of convenience. There is no prima facie case. There is no irreparable loss to them because they have committed fraud, my lord. And there is a finding by civil court saying that they have committed fraud. Even your lordship has. The arbitral tribunal says that there is a fraud, and Kulja is covering, my lord. Kindly see, Kulja has given this.
Let's see.
Give me Kulja judgment. Kulja. And your lordship judgment, in fact, I am covered by your lordship judgment also, my lord, in RMSI matter, which blacklisting matter came, my lord, where your lordship has said that fraud is the basis for this, sorry.
You need it. Yeah, please. No.
No, you see, the only thing courts examine whether if the blacklisting is disproportionate to, whether that elements of fraud have been to such an extent that, in this present case that we are.
Yes, my lord.
So that's the only thing.
In this case, there is a finding by arbitral tribunal, there is a FIR, there is a admission, my lord. All these materials taken.
All the ingredients are satisfied.
All these ingredients are satisfied, my lord, and therefore, in this case, my lord, the lordship may have it at an early date for final disposal.
Yes.
With 10 days, but don't, because the interim order is, my lord, is completely against the teeth of law. With my humble submission, my respect
between
and my lord, they cannot be allowed.
Contract and because the one thing that strikes the mind of the court is that if it is a case of fraud, there will be other incidents of which will be maybe reflected in the arbitral from your submissions. But the thing is that the entire disputes only with regard to the ledgers that they have produced themselves.
Now, my lord, kindly appreciate, my lord, kindly appreciate.
Manner, those.
No, my lord, now that is why investigation has to go into, because thanks to them. Thanks, I am grateful to them. Grateful to them. I am really grateful to my friend, my lord, because otherwise, if they would not have placed the material.
The question that arises, which we will of course examine, is whether these acts of transgressions or whatever you say over such an extent that it will warrant blacklisting.
Not only blacklisting, 1313 crore became 2400 crore rupees, and over and above, and now every award is suspect, and that is why
we're looking at this stage only.
Just
at the threshold. That's the only thing.
This case, my lord, what do I need to show to this court, my lord? That whether there is an admission of corruption or not. Yes, there is an admission of corruption. There is an admission. These vouchers are not my vouchers, and my lord, these corruptions take place under the clandestine mode. This is only tip. Your lordship has observed rightly that this is.
That's what you're trying to insinuate. That
this is a tip of iceberg which they place it. How much money out of 2400 crore has gone to officials and everybody? That is also reflected in the order passed by the The arbitral tribunal, my lord, please, in this case, my lord, I beseech you, lordship, that this is a case where the fraud is rampant. Please do not, and they are taking us for granted. They will offer some wine bottles and they will get the favorable letters and admissions. That is that kind of message should not go, my lord. This is a gross case, my lord, in my humble submission. And FIR also is there, investigation is going on, and even arbitral tribunal has given the entries. These are not my entries, my lord. These are entries by them. So they say that witness was not confronted.
In a concise manner, because if you scrutinize it, it's only proportionality of
And 5 years, my lord, they should have been permanently barred. In Kulja, they should have been permanently barred. That is the thing, my lord. In my humble submission, my lord, this is not a case. We have huge respect for learned senior advocate, my lord.
So your submissions are that it is not a bona fide dispute of a violation of contract.
It's not. It's a clear-cut case of
whatever's already apparent on the face of the record itself with regard to the infractions.
I'm grateful. I'm grateful.
Number 3 is that these acts, like it
cannot be condoned. These acts cannot be condoned on the face of it. And fourth, my lord, I am also supported by an arbitral tribunal which has gone painstakingly.
What stopped you from
now the question is, my lord, that why did not in 2019 the file and why did I start in 2020 and 16,000 volume, my lord, and entries.
16 volumes.
16, I have got that data, my lord. 16 volume running into more than 16,000 pages. 16,000 pages, my lord. They cannot make it. They cannot make this issue lighter. That look, 2019 I did the corruption and you discovered in 23. Therefore, corruption is washed out. Corruption is gone, my lord. And kindly see Kulja, my lord. Kulja. Paragraph 21, my lord. The legal, and in this Kulja only the corruption of 7 crore rupees. This is in my case to corruption of more than 1300 crore, my lord. 21. The legal position governing the blacklisting of suppliers in USA and UK is no different. USA, instead of using expression, my lord, kindly come to these guidelines prescribe the following among other grounds for debarment: conviction of or civil judgment. My lord, kindly see. 3. Commission of embezzlement, theft, forgery, bribery, falsification. And there is a civil judgment on this count, my lord. There is a civil judgment on this count, my lord. 23, my lord. Order of will remain effective guidance. In this case also, my lord, corruption of 7 crore rupees and there was a reconciliation of account. That debarment order was upheld, my lord. So on merit also, my lord, this is a case where
yes, there's not a decision also. We discussed this.
Yes, this is a case where the finding is there, material is there, corruption is there, my lord. And therefore, the parameters for granting interim relief, my lord, balance of convenience, prima facie case.
It's only the question of timing.
Timing will not make prima facie case, my lord.
You file affidavit, we'll hear it after 2 weeks. Yes, we'll finally hear it. Heard Mr. S. Punita. This is in WPC number 24.
23 also, Your Lordship.
We'll record 24 first and 23. You accept notice on behalf of all the parties?
Who are the parties?
Issue notice. One respondent. The other general is present with so and so accepts notice on behalf of respondent, so no further notice is called for. Stop. This is the main case. List this matter after 2 weeks. The respondents to file affidavit the meanwhile. An endeavor shall be made to dispose of this matter on the next date. Right, same order in 23. Then come to the where's the miss case? 23, 24.
Miscellaneous application.
This case number 11. Item petition.
Sir, thank you for building my flat in Supreme Tower.
So this case number 11 in WC number 24. This is an application for stay of the interim order dated 3/12/2024, issued by the Office of the Chief Engineer, bracket NH, Roads Meghalaya, blacklisting the petitioner. For 5 years.
One issue is that the SLP was dismissed with regard to the claim number 1 on 7th August 23. Thereafter, the matter of the second hearing started, because before that there was no occasion to go into all those records, because second claim started only after dismissal of SLP.
DRB had already given us a second claim long ago, and before DRB all these submissions were made.
Did not become.
Sorry, yes.
Are you going to?
Yes. For 5 years from participating in any future tender contracts of the Public Works Department of Meghalaya. You've heard legal counsels for the parties stopped on the prayer for interim stay. Next paragraph, Mr. S. Muglia, the senior counsel for the applicant, has placed reliance on the submissions and pleadings made in the main writ petition, submitted that the entire premise on which the blacklisting order was issued was with regard to ledger records which had been placed in the course of the arbitral proceedings as far back as in 2019. It is further submitted that in these ledger accounts, the ledger accounts relates to certain amounts which have been given to certain entities in the course of the business, and course of business which includes Christmas gifts and CSR activities. If I submit that the alleged infraction not amounting to the violation of the terms of the contract entered into with the parties, the order of blacklisting is disproportionate and calls for interference at this stage before the final matter is heard. Next paragraph. Mr. Learned Advocate General, on behalf of state respondents, has submitted that on the face of the record itself, it is a case of admission by the writ petitioner as to acts of gratification which have influenced the proceedings, arbitral proceedings,
and DRB proceedings also. And DRB proceedings.
And DRB proceedings. And at this stage, in view of these circumstances, no interim orders are called for. Considering the facts of the case, though it's apparent that the entire allegations that have been raised and criminal proceedings initiated on the basis of the ledgers that have been placed before the arbitral tribunal, it is seen that it is however seen that it is necessary that the objections of the state respondents be put on record before the matter is finally disposed of. So to enable the matter to be finally disposed of the next date. Next paragraph. Accordingly, the impugned order dated 3/12/2024 shall be kept in abeyance till the next date.
What was prayed, my lord, that they should be allowed to bid for in other, not.
This
shall be kept in abeyance till the next date.
Well, would your Lordships be pleased to have it on
This is the matter on
12th March if it's convenient?
12th March.
12th March will be too long, my lord.
No, I'm sure, my lords, they will not be able to file a reply before the end of the month.
3 days.
No, sorry.
That Meghalaya, we don't have too many matters.
Assisting counsels.
Very
They
well.
might be able to do it by tomorrow. If it suits the interest. Otherwise, they'll take months.
No, it's only that.
Yes, so 12th of March.
Please.
Yes, just a matter on 12th of March.
I'm obliged, Manas. I'm obliged.
We'll sit for admission hearing. We can dispose on that date.
I'm obliged. Deeply
Same
obliged.
order in item number 23, but petition number 23, but
We'll file a rejoinder to the before this.
that.
Yes, before that.
Just in the main case, 24, it is expected that the affidavit in opposition shall be in the record by 7th. Or is too long?
7th is fine, my lord.
By 7th of March.
7th of March.
By 7th of March, and the rejoinder there to file before the next date of hearing.
Please, Manas. We'll do that.
Same order in 20.
Yes, we'll pass him orders in view.
Deeply obliged.
Daily list item number 1.
Before the petitioner.
My lord, we are filing the rejoinder in the course of the day, my lord.
This matter is linked to the other case, correct? Why is it
My
kept
lord,
on this bench?
the cause of action is different, my lord.
The other cases, which is the way, where
It is
Mr.
fixed on Monday, my lord.
It's not linked to that case. We don't have any fallout on this case.
My lord, they are the subject
In
matter.
that case, they are challenging.
The rules, my lord.
Mr. Longbody is appearing there, correct? You are challenging the
rules, my lord. Excise amendment rules.
The rules whereby
the central bond
one central bond was been created.
My lord.
And in this case,
Now the
affidavit filed there, my lord, by the state, they have approached this.
no, there
state is filing an affidavit saying that the government is proposing to set up some more central bonded warehouse.
so they'll be in support of this case.
Yes.
So then it has a link.
But I'm filing rejoinder today.
Yes.
But the interim order candidate.
Lords, I'll just take a pass over, Lords. The Advocate General is
I'm filing
appearing.
rejoinder today.
Lords, may have it because he is in the division bench. So
At
I'll
the end of the board,
yeah have it in end of the board. Lords.
what do you have to say? He wants to close the matter
There
today.
is something to be said on the stay, Lords. So let the Advocate
Have
General
you put an
address.
application for vacation of the stay
Well,
or non-continuance?
The Advocate General would be at a better position to answer that. Lords. Have it at the end of the board,
After a
Lords.
list of some time.
Obliged.
I don't understand. It should have been tagged together with the other because it's.
My lord, I'm led by Mr. Mishra, my lord, in this council.
Suppose the court gives a finding here that it's it is fine that there be many other central bond warehouses. Then if that matter goes,
Let it come, my lord.
There is some sort of a overlap.
exactly. That's what this court's concerned about.
Obliged.
My Lord, we have filed the affidavit from the side of Managing Committee. My Lord, with regarding to this matter, the Managing Committee actually soon after the order of the passed by the Honourable High Court have set for the meeting within a week, and then had set for the meeting, constituted the inquiry committee, and the due process already started. Statement been recorded, but what came to a standstill when they issued notice to the petitioner for show cause, the petitioner refused to accept notice. That's the only thing.
Actually,
Now,
just-
if they have given the, it's only for them. If they accept the notice, then we can give the report within a week or two.
Lordship, I've just received the affidavit today morning. I'll just go through it and Lordship, I'll come with
Just
instructions.
contempt.
Lordship, I just received it today, Lordship. It'll come after 1 week.
Are you complying the order? That means
If they have
Lordship, there are
complied
two
the
parts.
orders,
There are two
comply
parts.
orders.
There are two parts of the directions to the managing committee. One part is to release the back wages to the petitioner, and one part is to hold the inquiry, Lordship. Now, the first part is not complied with, Lordship.
back wages.
Back wages, Lordship.
How much you do?
From December 23, Lordship. Because the order says that until unless the inquiry.
Mr. P. Dokrut, who on behalf of the sponsor submits that affidavit has been filed. Stop. You won't file anything.
We filed, Your Lordship,
Yes,
correspondence 1 and 2.
This is a matter for 1 week for rejoinders of any.
Lordship, I have one more submission, Lordship. The respondent contemptor here is respondent number 3. He's the secretary representing the managing committee. Lordship, the affidavit that has been filed by them is by a different person, Lordship. He's not the secretary.
Then that you can take.
I can take a rejoinder.
He'll go against them. Yes.
Lordship. Hello.
Item number 3.
Please, Your Lordship.
The judge has been filed.
Lordship, I'm praying for one more week, Your Lordship, to file a
We
rejoinder.
indicate interim order.
Lordship, one more week, Your
Okay.
Lordship.
Yes, sir.
Lordship, just one more week, Your Lordship.
It's obstructing the construction of the road.
Yes, Your Lordship.
Just one more week, Your Lordship. Let this be his last chance, Your Lordship.
When was the interim order passed first? Only for the plot of the petition. That is since
31st.
the interim order operating since
July.
Since July.
31st July 24.
We'll close rejoinder. You ready? You have the file with you.
Lordship.
You ready with the matter?
Lordship.
Mr. Praise that, also mispraise that this is further time to file an affidavit stop. It is noted that the interim order has been operating since July 2024 and the matter concerns the construction of the highway, right? Of the national highway. From this view, the matter last opportunity of 1 week given for a joinder, failing which the interim order is then vacated. But you come prepare after 1 week. For the joinder, will finish it out.
Item number 4.
Since people don't do hearing, you might as well start doing the hearings and the order stage only. You all come prepared. Yes.
May I please, Your Lordship? You're supposed to file the rejoinder.
Was pension matter?
No, Lordship. Pending bills, Lordship. Some more time to affidavit.
How many times have you taken for rejoinder? How much time? How many opportunities have you given?
Second time, Lordship.
My last, I would say, of 2 weeks granted to the petitioner for rejoinder. Yes.
Item number
Use
5.
the same for hearing in the meanwhile. Yes. Yes. Number 4.
Lordship, I am appearing for respondent number 4.
Mr. Marak.
I pray tomorrow each time, Lordship.
You're for number 4?
Yes, Lordship.
How is it entering upon you? Already appeared last time also. Entering appearance means first time you appear. Okay, not entering appearance is first time. See, Mr. M.R. Marak. What about 1, 2, 3?
We have 5.
Already 5. Responsible for the 2 weeks time for activities thereafter.
Item number 6.
Please, Your Lordship, shall be service and respondent.
Yes, yeah, Your Lordship. We are entering appearance.
Half of?
Respondent number 3, and we'll be filing our power during the course of the day, Your Lordship.
Number who's beating the ear appearance for number 4? CCT Sangma 1 and 2.
1 and 2.
And 3 is who?
Yeah, Your
3
Lordship.
is who? Which?
The headman, Your Lordship.
Admin. Okay. What is this grievance? What's the case about?
Your Lordship, here basically they are praying for convening the Dorbar Shnong, Your Lordship.
Okay, MS Lekha appearance on behalf of respondent number 4, and as such.
Respondent number 3, Your Lordship.
Sorry, as such, notice complete on the respondent. Have you all filed affidavits?
Your Lordship, if necessary, we will file, Your Lordship.
You're not filing? We're not filing. You already filed? Why you have not filed?
Necessary will be filing.
What means you'll be filing? That means you know affidavits, then you proceed with the matter.
Yeah.
Yes, the respondents.
Your Lordship, this is the first time I'm appearing, Your Lordship.
Respondent number 1, 2, and 4 submits that affidavit will be filed if necessary. So, however, MS Kharsi on behalf of number 3, please will have to examine the matter as to whether affidavit will be filed within 2 weeks. Yes, listen to me.
Much obliged.
Item number 7.
Yes, where's the affidavit?
Lordship, we have filed the affidavit.
Selection, where's Mr. Hassan? You're Mr. Hassan, correct?
M. Rahman, Your Lordship.
No, you're Mr.
Yes,
Hassan.
yes, Your
Where's
Lordship.
Mr. Hassan?
He's on leave today, Your Lordship.
That's
Lordship,
not on record.
Lordship, we have filed it.
You reserve your copy?
Your Lordship.
Yes, MS S. Lalu, correct?
Yes, Lordship.
Submits the affidavit filed, though the same is not yet placed on record. MS Around, however, submits that. She has received a copy.
Yeah.
Only says matter of truth or rejoinder of any.
Yes, Your Lordship. After 1 week, Your Lordship.
1 week.
1 week, Your Lordship. Much obliged. Obliged, Your Lordship.
Item number 8.
Please, Your Lordship, I'm appearing for respondent number 9, entering appearance to the Lordship.
Number 9.
Number 9, Lordship. It's a bank.
Mr. Gurung 1 and 2. 1 and 2. Then how many
Lordship,
responses are there?
9 in total, Your Lordship. 9. Lordship, service with respondent 3 to 8.
1 second. 3 to Telangana State Police. Oh, Telangana Andhra Pradesh. 3 to
8.
8.
Lordship.
What happened to the notice?
As per the online portal, Your Lordship, your service has been affected, Your Lordship.
On Telangana Police.
This is not maintainable.
See, no commissioner in this address. This is from Telangana. They returned it back to you.
Lordship,
We verify the correct what you call designation of the officers who you think are responsible. Otherwise, they won't accept it. You can go to the website and find out who's the commissioner, who's the secretary in home police. If they have a home police department, they might have some other department. But you have not made the commissioner. How did they have commissionerates, with regard to police administration, unlike out here. Guwahati also, I think they have now commissionerates. Assam rather. Mr. S. Marpan sent his appearance with duty and behalf of number 9. Stop. With regard to the respondents number 3
to 8.
The council prays were allowed to obtain the correct designations and addresses and to take fresh steps thereupon.
My lord.
Praise allowed, yes.
My lord, in fact, my lord, this writ petition is not maintainable at all, my lord.
That you can let them try to effect service first. You want to file affidavit?
Yes, sir.
Yes, Mr. S. Marpan pays for the allowed 2 weeks affidavit. List after 2 weeks for affidavits and for report of service on the other respondents. You take steps are taken within 3 days. You get the correct address.
Item number 9.
My lord, as per the last order, steps have been taken and notice has been served to all the private respondents.
Lordship, I am appearing on behalf of the respondents number 7 and 8 in this matter.
No. One second. One second. What's the case about?
This is a land compensation matter.
Okay. Number
5, Your Lordship.
Yeah, their appearance.
Yes, Your Lordship.
Then number
for number 7 and 8, Lordship.
7 and 8.
Yes, Your Lordship.
Okay. 6. Who's appearing? 1, 2, 3, and 4. That is you. Then only number 6 unserved. Yes. Mr.
Your Lordship, if I may.
Yes.
Submission, Your Lordship. As per the relief that I approached before Your Lordship, they have prayed that proper for the DFO to take cognizance of me, Your Lordship. However, they have made specific prayer to register appropriate cases against me. However, Your Lordship, the matter has already been compounded before the DFO.
Affidavit.
Yes, Your Lordship.
Then make the case instructions. Yes, where's Mr. Yubin?
It's on Lex, Your Lordship.
Yes, Mr. S. Arlindo has an appearance on behalf of respondent number 5, Mrs. Aim on behalf of 7 and 8. No appearance has yet been made on behalf of the respondent number 6, and the service report is also not available at the moment. Stop. Accordingly, list the matter after with affidavits by respondent number 5, 7, and 8. Are you filing comment?
Your Lordship, as per the last order, we were supposed to get instructions. Your Lordship, we received incomplete instructions.
List after 2 weeks, yes, for affidavit and for instructions or affidavit by for affidavit by respondents number 5, 7, and 8, and for instructions or affidavit by respondents 1 to by the state respondents 1 to 4. Yes.
Highly obliged.
Item number 10.
Please, Your Lordship, I'm appearing for District Council. Your Lordship. We're supposed to file the inquiry report and the list of the electors. So I'll be filing it in the course of the day. Your Lordship. Just give me some time.
What matters this?
Suspension of the Sirdar of non-considership.
It is a case, my lord. I am for the implicated electors only, no, my lord. It is a case, my lord, where the Sardar has lost the confidence. I am representing 5. Out of 7, my lord, 5.
Oh, that one where there's no proceeding.
There's no.
Yes, my lord. 5, my lord, I am representing. 5 have withdrawn their support, my lord. How can
no, the thing is that
Lordship,
was there any proceeding, any finding generated on the complaints, or what was just simple?
We could not because
no, this is a removal, correct?
Removal.
Suspension.
Suspension, my lord.
Which has
The rules say,
suspension.
my lord, if you
Lordship, this is my second removal. On the first removal, there was an inquiry. I was reinstated back into the post. Now, this is the second complaint based on the same allegations, same set of complaints. I've been suspended twice.
Okay.
Twice. Now, Your Lordship was of the observation to produce the
affidavit then.
Today, during the course of the day.
Mr. Armarpan submits that the affidavit on behalf of respondents number 1 and 2.
As per the last order, I'm supposed to submit the inquiry report of the judicial officer and also the exact list of electors to the office of Sirdar.
Yes. 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 Let them file inquiry report, we'll examine it, and if what they say is correct, then your case goes.
Lordship.
Yes, Mr.
Lordship, only thing, my lord, I have filed an application for vacating stay, my lord. He has lost the confidence. 5
So
years
that
before
will take
this.
up, let them
Only,
file,
my
let
lord,
them
next,
file.
he's
We'll
filing.
unless the matter after 1 week.
1 week.
Mr. S. Marpan to file the what the required records in the meanwhile. Stop miss case, all on miss case number so. List this matter together with so after 1 week.
1 week Friday.
Lordship, I may submit, Lordship. Lordship, there are other respondents whereby notice have not been issued. Who are the main complainants in the complainants? Lordship, there is respondent 5, Lordship. No notice 5 and 6. No notice has been issued.
You have not issued notice. You have
No,
not issued
no
notice.
notice. No notice issued.
Then let's say after 2 weeks.
I'll take steps.
Notice on response number
5 and 6, Lordship.
5 and 6 in the meanwhile. Yes. Within 2 days. Yes. Right.
Should the interim order may continue.
Interim order is till next day. Yes.
Obliged.
Item 11.
My lord, this is relating to that boundary dispute, my lord. After 2 years almost, my lord, the executive committee has referred the matter to the tribunal. Last occasion, lordship granted me a stay pending filing of affidavit. I have not received any affidavit, my lord. So at least the stay order to be extended.
We need some more time to file the affidavit.
Only the, my lord, that interim
Is
is...
Longjong village that one with the sunrise?
Yes.
What's the dispute about?
This was a boundary dispute, my lord. This was settled way back 2017, my lord, finally.
was
Then they
revived
preferred an appeal, my lord, before the one-man tribunal, almost after 2 years. So that was rejected, citing the provision of the statutes. Now, after that, my lord, suits were filed, suits were dismissed, they come back to the executive member. Now, executive member, my lord, condoned the delay without citing any reason after almost 4 years.
Now,
Said,
now you mean that the proceedings are over in the tribunal again?
Lordship?
Still
No.
still going on?
No, not going on, my lord. Proceeding, my lord, when the proceeding was, my lord, referred to the tribunal, my lord, after 4 years, I came before this honorable court. And my lord, appreciating the requirement of the statute, which is very clear, my lord, within 1 month. And there is no provision for condonation. So, lordship, my lord, pending filing of the affidavit, lordship has stayed the proceedings. So, my lord, let them file, my lord, in the meantime to continue.
You're paying for whom?
I'm appearing for the private respondent number 6, Your
You
Lordship.
file affidavit?
No, Your Lordship, I'm also
Why
paying
you
for
haven't filed?
I'm also paying for time, Your Lordship.
Yes, further 2 weeks' time granted to the respondents number 1 to 5.
Yes, and
1
7.
to 5 and 7. It's presented by Mr. Arkhasat and respondent number 6, similar appears now brief for filing affidavits. Yes, there are so and so and so, and meanwhile, interim order shall continue.
Obliged.
Item number 12.
What's the matter about?
Your Lordship, this matter pertains to the upgradation of Norimba village to a new locality, Your Lordship. Norimba locality to a new village, Your Lordship.
Bifurcation?
Lord, upgradation, my lord.
Upgradation.
From a
Upgradation
dong to a
New
Shillong.
separate village.
Lord, in fact, nothing survives in this matter because the interim order, my lord, amounts to final order, my lord.
What does it say?
Lord, kindly have the interim order. Lord, by way of the impugned order, the same was directed to
Or it's not before? It was not. When was it filed? This one?
during vacations, my lord.
Oh. What's the interim order?
So, my lord, during pendency of a political appeal, my lord, an order has been passed by the executive committee directing this aim to hold a public hearing on the upgradation of the Norimba Dong, my lord. My lord, they have approached this honorable court seeking for a stay of that meeting. However, on the day when the my lord, meeting was scheduled to be held, or it was already held, was being held, the matter was taken up and a stay was granted, and the a direction has been issued to proceed with the political appeal, my lord.
So what happened is, the meeting was held.
Meeting was held, my lord.
And then, so the matter's in fructuous now.
In fructuous, my lord, nothing. It's a final. What I'm trying to say is, Lord, if your lordships kindly have the order.
Yes, the order is here before me.
Yes, my lord, para 9.
On considering the prayer made for stay and said hearing, as pointed out, it is court of to concede the prayer made at this point, and by this time, how as consequences. So what happened? You are appearing for the district council?
I'm appearing for the same of Malawi.
What happened is, hearing was done.
The meeting was already held.
And all the people want to be upgraded to...
The report, I'm yet to get instruction.
Well, what I'm trying to say now, yes, what I'm trying to say now is, my lord, however, as a consequence of such public hearing, if any report is filed or deemed to have been filed by the concerned authority, such report would not be taken into account till the disposal of the writ petition.
Okay.
In the meantime, the respondent KHDC is directed to dispose the political appeal. So what I'm trying to say is, my lord, this interim order amounts to final relief, my lord. So, my lord.
Oh, yes, who's happened to the council? What's happened to political appeal?
Your Lordship, actually, because Your Lordship, we have no instructions yet, Your Lordship.
My lord, in the
regarding this
political
matter
appeal.
because of the upcoming elections, Your Lordship. So my instructions are
yes.
if this matter can be
We take up after 21st.
after the
Now,
21st.
my lord, pursuant to this order being passed, the notices were issued in the political appeal to appear. There is a petitioner who sought for time.
In the political appeal.
In the political appeal. But what I'm trying to say is, my lord, there's no point keeping this pending. Let the political appeal be disposed of. My lord, it's...
Well, let the council, let Mr. Kintasan be here.
And moreover, my lord, the petitioner before your lordships, my lord, is not a party in the political appeal. Dorba Shillong is not.
Appeal?
My lord, it is in person, my lord. If your
Who is the
lordships kindly have page 31 of the petition. The cause title, my lord, page 31. 1, 2 and 3, my lord, Andrew Jirwa, Theory Murbo and one Nonkenry, my lord, in person, my lord. In bracket, they say they are all Rambashno.
Okay.
But these are in person. And before your lordships, it is the Lamkra Darbar Shnong Pullan, my lord.
Okay, Mr. Kramrambi entered appearance in behalf of the
5 and 6.
5 and 6. And Mr. Sindram on behalf of
Respondent number 4.
Number 4. Thosha, Mr. Sindram, number 4, and so and such. Notice complete in respect of all the respondents now. Next paragraph submitted by Mr. Philam Nongri on behalf of the respondents 5 and 6, that the matter has been rendered infructuous in view of the fact that the meeting, in fact, with the fact that certain developments have taken place, such as the meeting which has been concluded in the locality.
Yes, ma'am.
And that the political appeal is proceeding as per the orders of this court. So, we have no more role to play.
No, just following the instruction given by the district council.
Then next paragraph, however, MSc Nongkla on behalf of the respondents 1, 2,
1, 2, and 3, Lordship.
Praise the matter be taken up after the elections. After this council elections, praise allowed. This is a matter after 21st February.
Lord, may I also record that the petitioner herein is not a party in the political appeal. The petitioner herein.
That's not. Let that come in the final order.
Deeply.
Second call, item number 1.
Requesting your lordship.
Gown.
Oh, apologies, my lords. I'm requesting, my lords, the matter may be taken up at the end of the board. He's still
We are only filing rejoinder. Matter may come up next week, my lord.
There are certain, my lords, submissions to be made as far as the stay is concerned.
Well, that submission can be made on the next date also, because
So, my lords, there is something to be said, my lords. There is no order stay has been granted till the next date, my lords. So they have to argue a case of extension of the stay.
If the court
Yes,
doesn't
my lords.
rise, then yes.
Yes.
Let them come.
End of the board, my lords, keeps it.
Hearing. Item 13.
but these are those contempt matters since 2015, my lord.
My lord.
10 years, so now it's completed.
My lord, 10 years because it's complicated, my lord. It's not 10 years because.
This one is contempt is dead, Mr. Pathar.
My lord, let me
Even
summarize.
one
Let
of
me
the
summarize, my
governors
lord,
has
where I.
become Governor of Manipur, I think. No.
Let me summarize, my lord, in a minute, my lord, as to where I stand today, my lord. Lordship knows that these are matters where pay commission's benefit were to be implemented.
But
Pay commission said, my lord.
But the thing is that the thing is, it has taken many twists and turns,
my lord,
since the time the contempt was filed.
My lord.
So whether any effective orders can be passed, we have to look at that, not looking at the facts again. Whether at this stage any effective orders can be passed in the contempt application, which
when there
we
is
can't
a
ask for directions.
when there is a
we can't pass directions.
My lord, when there is a gross error.
Moreover, my lord, they have to change the array of parties again, my lord.
When there is a when there is a gross violation, my lord, the recent trend of judgments of the Apex Court is that when there is a gross violation, then certain orders, as far as my lord, the court has a duty to issue appropriate direction for remedifying or rectifying. Just punishment is not the only options that we have to look into in contempt, my lord. Where the gross error here lies, my lord, there were two aspects. One is that we were to be given warrant officers. Other trades have been
Where
given
was the
warrant
call?
officer.
What happened?
Uncle?
My lord, no, probably he's in Kolkata, bro. I met him the other day in Kolkata. For that reason. So the warrant officer part.
Mr. Paul is also not here after 4 weeks.
Of course, my lord. Just for the next day's benefit.
Put that in your mind, at least in the back of your mind,
my lord.
That what orders can be passed,
my lord. What?
You see, in the sense that we heard it at one point of time.
Yes.
And the court prima facie, whatever appears that it's changed course to such an extent that it's not a direct violation or get direct order for compliance. That's the only thing you have to show, that there has been a blatant, that there is willful, number one.
Where?
Number two,
Yes.
and then like it is, it's very clear that orders can be passed by this court, Otherwise, it'll just be again to.
What I am therefore, my lord, summing up the matter to is that the warrant officer part, of course, we have not been granted. That is, of course, maybe a new cause of action. Other trades have been granted, no doubt. But then for us, my lord, what had happened, we were given class 3 Havaldars. Havaldars, my lord, the compliance order that they passed 2 compliance orders in our matter. The initial compliance order, which comes with the approval of the Ministry of Home, it says that on 23rd October 2015, it says you are upgraded to and redesignated as Havaldar. That is fine, my lord, because that entitles us to financial benefits. But then without approval of the ministry, on 23rd August 2016, a second order is passed where they say that it is upgradation/promotion. This word redesignation is taken away.
But that has been addressed in so many petitions.
But these are
And even by this court also we passed orders that
release they're
upgradation,
claiming.
that promotion is, it is declared like, it's
What I wonder for my lord is that if the 23rd October 2015 order is held to be the compliance and not the second one, then our at least some
subsequent orders
why
with
don't they
regard
file a
upgradation and
request?
promotion. There's so many analogous cases where that has been set aside. That is not a promotion.
Yes,
that
my
is just
lord.
upgradation.
Yes, my lord.
So that is already there. So what remains in a contempt?
My lord,
That is
only
what
thing
this court wants to know.
My lord, the only thing is that the 2 compliances that have come, I
But
want
they are
to say,
seeking-
I want that, my lord, that
My
the
lord,
first compliance should be the compliance.
May I just submit, my lord? My lord, other petitions came before this honorable court
Yes.
by way of writ petition, my lord. Your
And
lordship
then- and orders
adjudicated
have
the
been
matter.
passed.
This requires a substantive adjudication, my lord. This cannot be pressed in the contempt, my lord. 10 years these contempts are pending.
No, why I am saying, my lord, that is
Okay. When's
within the
principal
purview,
coming
my
to
lord.
suppose next date? 100%. When will be available?
Up to 3 weeks, my lord. 3 or 4 weeks.
Okay, after 3 weeks, yes. Otherwise,
Because
the court's titles matter also. We don't like to see matter.
I also understand, my lord. I have.
At least in my bench, I don't want to see matter 2015.
My file has become one bag full, my lord.
But then I understand, my lord, that
Look at the condition of the file also. I can't open it also. All the pages that are torn.
what is difficult for us is, my lord, that they are interpreting the judgment in a manner.
For you, better close the contempt and start on a fresh page. And even these issues will be taken into consideration.
My lord.
That is what this court.
No, as of now, I am boiling down only to the fact that there are 2
Exactly,
compliance.
no,
If the
fine,
first
fine.
is held to
But
be
the
the
thing
true
is that
compliance.
what effective orders?
No,
are
I
you
believe,
taking?
my lord.
We can't pass effective
No,
orders.
I believe, my lord, when they say that we have complied, which one is the compliance? This
Alert
court,
counsel,
of course, this court, of course, can have an observation on the fact that which particular order is actually the compliance. If that is done, my lord, I need nothing more, my lord. No substantive relief. But then as to which order is the compliance, my lord, if some clarity is thrown on that, my lord.
Okay. We can't clarify contempt.
No.
Contempt between the
No, not.
contender and the court.
I'm not, my lord, asking clarification of the order because that will amount to review. But then, as far as the compliance is concerned, if they pass 2 orders, one.
Okay, we'll examine it.
They want
My lord.
substantive
16.
adjudication.
No, I know, because they feel that they don't. Why Mr. Pathak is pressing this contempt? Very simple. They want to go the rigmarole of starting from square one again. You see, they want to go from there.
Most
That
of
you
these
take
persons
time
have
for
retired.
affidavit,
That would simplify
and then
the
after
matter.
affidavit is filed after 1 year, then judgment takes another 6
My lord,
months.
I undertake to file
then it
affidavit
goes
within
for
1
an
week,
appeal,
1 month.
Then the appeal, file SLP, then it'll come back SLP again. So he doesn't want all that.
And a majority of persons have retired, my
So
lord.
that's what he
That
can't
is
get
the.
them all together. So they see.
I think that is the main difficulty is that.
Why the contempt is being maintained is just for logistical reasons, nothing else. I think the court's correct.
My lord. Plus, most of them have retired, my
It's all
lord.
logistical reasons, just to get the logistics together,
My lord.
and that's the only thing. Otherwise, yes. Where's the petitioner?
Applies, my lord.
16.
May it please your lordship. Lordship, my apologies, my lord. Conducting counsel, Madam S. Prasarji, she is on sanction leave, my lord.
What's the matter about?
Lordship, I don't have the brief with me, my lord. I was just instructed this morning.
You're appealing for whom?
Your Lordship.
Oh yes, I know this case. Just this continuance. Yes, sir. As the arguing counsel on sanction leave, this matter for 2 weeks.
Deeply obliged.
Yes, sanction leave, correct?
Lordship.
17.
All right.
Yes, start.
I beg to mention, yes, Your Honor. I beg to mention, Your Lordship, item number 17. We are praying for time, Your Lordship. Let this matter will come on 14, Your Lordship. As the conducting counsel from Guwahati, he'll be available on 14, Your Honor.
What is your name?
Oh, sorry, Your first time, Your Lordship, I am here.
Yeah, what is
My
your
name
name?
is M. Surong. Miss M. Surong. Yes, Your Lordship.
How long you practice?
I've been practiced for 4 years, but I used to practice in a trial court. So this is the first time I've
Very
been here
good.
in
So
the
you
High Court.
memorize what you have to what you have to mention. You memorize it before coming.
Yes, Your Lordship.
Good.
Honestly, a little bit.
See, it doesn't matter. You don't have to be nervous. All courts are the same.
Okay, Your Lordship.
Yes.
Thank you so much, Your Lordship.
When we fix it? After view?
Let it come on 14, Your Lordship, because we have some other matter also which is fixed before this honorable court
not
on the 14.
The Friday, the court doesn't like to fix long hearing matters.
After 2 or 3 weeks.
Then come after. We'll have it on. You tell Mr. Who's your counsel?
BT Conver.
PD Conver, yes.
24th, 25th.
20th March, 20th February.
20th
February.
February. Okay, Your Lordship. Much.
It's on the prayer of your name, Surong.
M. Surong.
Who submits that arguing senior counsels are available today. List the matter on 20th of February 2024. Yeah.
Much obliged. Good day.
Item number 1.
See, you don't come. Alut matter.
My lord, the learned AG, he's on next before quorum number.
It'll take a long time, I think. So that court is not a speedy court, I think.
I'm only filing rejoinder ballot.
Yes, Mr. Dr. Emerson submits a rejoinder file the course of the day. You file goes there. This is matter up to 1 week for further orders. Yes.
The interim order can take.
Interim order shall continue the next day.
Deeply
Deep.